The reality is that scriptures say it is appointed unto man once to die. Death smiles upon us all, said a philosopher. I have found in my practice that there are people, when you talk about writing your will, they frown upon it because there's this reservation, perhaps a feeling that if I make my will today, I'm going to die tomorrow. But you're going to die anyway. Yes. I made my will years ago. In fact, I made my will when I just started practicing, about 17 years ago. I made my will. And the reason I did is because I know that not doing so would not have been the most prudent decision. Yes? So as I said, I'm going to talk about estate planning. I definitely will speak about wills more. But I will talk about estate planning as a broader concept. And basically, estate planning is what we would term as the arrangements that you're going to put in place concerning your estate, and I'll explain what that is. And these arrangements are the ones that you'd want to take place in the event of death, injury, or incapacity. So we're going to talk about will, but estate arrangement goes beyond what happens when you die. Of course, that perhaps is the most important decision, but the reality is that some of us, before we die, we may become incapacitated. Yes? I have seen it. People get dementia, Alzheimer's, in an accident went into coma. So the reality is that, and these things are not respective of age. When I was a little girl, my great-grandfather used to say that the young may die, but the old must die. But when we watch the news, we wonder if it's the reverse. Not true. Because when you look at the accidents, it's always young people. 90% of the time, young people. The killings, 90% of the times, young people. So the reality is that it is a part of life. Unfortunately, these unforeseen events, they are a part of life. And if we knew that we were going to crash, we wouldn't bother to drive. Not true. We don't. And so we put things in place. Yes. And there are several tools which you can employ. Everybody can hear me. If you can't hear me, tell me. I have a big mouth, so I can project if I must. Mr. Matt, don't say amen to that. So what is your estate? You might say, what does that mean? Anybody knows what an estate is? Yes, we're in school. You see, I was hoping to do my PowerPoint presentation, but I have some challenges with my laptop. So I'm not going to be the only one speaking. I want to hear from you. Anybody knows what we define as a person's estate? Property, yes. And what is property? Interesting, eh? All right, you're halfway there. So the estate is any property that you own or control. Yes, but here's the thing. Property in our own language, our own vernacular, we think of property as land. But in law, property is more than land. So we have what you call real property, which would be land. And leases, because you have people, for example, who have their 100-year lease. And that's something that you could leave on a will as well. So interest in land, that would be your real property. But we also have what is called personal property. And that's, for example, your bank accounts. So before I say that, so you have some people when they say, make a will, but me not have nothing. It's not just land. It also includes your personal property, your bank accounts, your shares, your stocks, your debentures, your cash, your furniture, your jewelry. You might have a business or interest in your business, your debts. People owe you some money. All of that is a part of your estate. Yes? Not just your insurance policies. So when you go from here and we talk about property, the first thing you would have learned is that property in law does not mean land or what we call real property, but property is also what we call property. And that would be basically anything other than land. Yes? And so basically when we talk about estate planning, what we're saying is, what kind of arrangements have you put in place concerning your personal property, your land, your bank account, your insurance policies? What arrangements in the event that you die or you get sick? Yes? You're injured or you're incapacitated. And several persons are normally involved in this process. These include lawyers, accountants, insurance agents, bankers, brokers. Sometimes they're not. You might say, boy, but we don't have no money to pay those people. But it depends on what it is that you're doing. Because, for example, if you're doing an insurance policy, that would involve your insurance broker. Yes, you want to write a will that may involve your lawyer. You have a bank account that involves your banker. So you don't have to think, oh, I need all these people. No, it will depend on what it is that you own. Yes? And why do you want to plan for your estate? Because it's a prudent thing to do. You know, Solomon talks about consider the ants. It's a prudent thing to do. In the same way that we're supposed to put our spiritual house in order, we're supposed to put our physical house in order as well. Yes? And I can tell you, in fact, it was a discussion that I had with Pastor Johns, which initiated this. A discussion about estate. And, you know, you'll be surprised some of the things that happen. If you recall, you remember that incident that happened in, where was that, Trelawney? Trelawney, right in the middle of church. And remember, it is alleged, and I'll put alleged because I don't know what happened, I wasn't there. It is alleged that this was over deadlift. So I'm saying the reason you need to plan out your estate, put your estate planning in place, is because that is what a wise person does. If you care about your hard work, if you care about your children, and even yourself, it is important for you to do this. I remember having a discussion once with someone, and I basically said to the person, listen man, you gotta put your affairs in order because of what's happening with your health. Because if you don't put it in order, somebody will, and you may not like what that person does. Yes? So here's the point I'm making. You may have your child, and it doesn't mean that your child is the best person to take care of you. That's the reality. I mean, we see the first murder took place between a brother and a sister. Not true? Yes? And so you might find that you say to yourself, boy, my children will take care of me. But if you know that you have Mary and you have Jane, and Jane is going to squander the money, you perhaps will want to put a power of attorney, for example, in place so that the other child will know what to do in the event that you become incapacitated. Yes? So basically, it allows you to determine what should happen to the things that you have worked hard for. It also allows you to put certain mechanisms in place for your minor children. The reality is we see it all the time. A lot of persons die and leave small children behind. It's one thing when they leave the big people, but I'm telling you, small children, and sometimes ultimately they're left to the mercy of the world. Yes? And why it is important for you to put the mechanisms in place. Let me just give an example. I'll probably repeat myself a little bit later, but just to give an example. I remember I had a situation where a mother died, and she did not put in place proper trust provisions for her child. And when the child turned 18, basically the child said she wants her money. So she demanded the money from the other relatives. And this mother wanted her to have the money for university. So now at 18, she decides, I want all my money because it's my money, I'm going to want it. And the money was given to her, and within 6 months, millions of dollars disappeared. That's what happens when you don't put things in place. Yes? So you get to put certain things in place for your children. Yes? And you also get to effect your wishes without having certain legal blocks to surmount if you didn't plan. So let me just give an example. So if you put a power of attorney in place, for example, and you become incapacitated, There is no need then for anybody to go to the court to get an order for somebody to be appointed to take care of your affairs. Yes, because you would have determined who you wanted to do that. All right? And generally speaking, what we're saying is that when you plan your estate, it's you who decide what happens, not somebody else, not the government. You can use it also as a tool for tax avoidance, and it is less time consuming when you plan properly. Just to give you an example, I have had wills, and people come, and when you look at the will, because an attorney did not write it or somebody who, was competent, you find that they leave the bedroom to Mary, the bathroom to Jane. I mean, we don't know how to share that up. Because when you look at a title, we can't talk about bedroom, bathroom, and kitchen. We can't, And then you look at, and we don't even know what to do. You get these things, and it's just a headache. That's why I'm saying when I get opportunities like this, I take it because basically I am saving myself some of the headaches and others, some of the headaches that we see in practice, yes? Your estate planning also helps to determine your funeral arrangements. So you can put in your arrangements, I want to be cremated, I want to be buried up yonder, whatever, you can put that in. And one of the things that it does as well is to eliminate the consequences of word of mouth. I am tired, people come to me, did your mom leave a will? No, but she said, me forget it. Sir, anybody can say anything. That's the reality. Anybody can say anything. And so you don't want that. It's always better to put it in paper. As one judge would say, black and white, yes. That is where we want you to be thinking, right? So estate planning allows you to avoid the cost of costly probate. It gives you control. And we have a term that we say it helps you to speak from the grave. So we might say death has no power, but it has some power. So you're gone, but you're able to speak from your grave. Yes, that is why it's important for you to plan your estate effectively. Also, normally when a person dies and leaves several properties, the fees are very high. If you're going to sort out that estate called administration, there are lots of fees that may be involved, and proper estate planning will allow you to cut back on some of those fees that are to be paid. So for example, you might decide to give the child the house in question while you're alive. And so when you think of inflation, the taxes that you would pay today would be much less than the taxes that they would have to pay tomorrow when you have gone. And some of the costs other costs would also be cut as well. Right? Just to point out, transfer tax is now about 1.5% of transfer taxable assets, such as land or shares. Attorneys' fees for administering estates about 5 to 8% of the value of the estate. Also, personal representative commission, you're looking up to 6% of the estate. So if you see what I'm saying, a lot of costs are involved. But when you put the right things in place, it will help to eliminate some of the problems for your children. I have seen children, many, many times they'll come, mommy left a piece of land over yonder. And you know what happened? Them said they don't even bother want it, them can't bother. Because when them hear about all of the processes and the fees to have it sorted out, they just say forget about it. And you don't want that. You don't want that at all. So my hope is that it doesn't matter that more persons are not here. The Bible says 1 can chase 1,000, 2 can chase 10,000. When we tell you, you tell somebody else. That is what discipling is all about. So the fact that I've told many of you, just think about if each person communicates this with 10 other persons, 5 other persons, it would spread like a fire. You do what you need to do, all right? So please make sure, and if you have questions, do not be afraid to ask them. So what are some of the tools for estate planning? One of them, of course, which we're going to be talking about and deal with shortly, would be wills. Another one is trust arrangements. So basically, you can put arrangements in place where a person can hold a property on behalf of another person. And you might be saying, what does that mean? So to give you an example, if you were to go and open an insurance policy for your children, for their education for university, as I did for my small sister. Because she was under 18, the bank said you have to name a trustee or you have to name 2 trustees. So in the event that something happens to you, those 2 persons would be the persons that would be able to hold the money, handle the money on behalf of my younger sibling. So that's really what a trust arrangement is. There are other kinds. I just gave you that as an example. So you see where we're going. And trust documents are normal. Well, it's normally done in writing. And you can put your wishes down. And we see trust documents coming into place where sometimes people may have a secret child, that they want to take care of. I'm not encouraging anybody to go and have secret children. I'm just saying. And you may put arrangements in place for that. Yes, it basically helps to determine how the property is managed. So one of the things I oftentimes encourage my clients to do when they're writing their wills, because we can also put trust arrangements in the wills. For the children, I say, do not release the entire property to them until they're about 25. Because I believe it's about that age that people make smarter decisions. And I'm not knocking anybody under 25, I'm just saying, a fool and his money shall part soon. And foolishness is in the heart of children, the scriptures say. So it's better that you put things in place and save them from themselves. Not true? Just to give you an example, I remember I did an estate where the child got some money. I don't remember, it's years ago that I did it. So they sold the house and got some money, say about 11 million. And every month the person would come for another million. Every month, young person, And by the time we finished, there wasn't much to give. I said, boy, I wonder what I'm doing with this money. Just when you put arrangements in place, you save some of these things from happening. Yes? So some of the things that you can put on trust, your bank accounts, land, motor vehicles, business interests, stocks, and so on. You can have your revocable trust or your irrevocable trust. So what that means, basically, you can set it up that you can go and change and say, I changed my mind, I want to do this instead. Or you can set it up where you say, this shall stand as long as I live, and I don't want to change it. All right? Another tool, so we talk about the trust. Another tool is gifts. We call that in law inter vivos transactions. So basically, when you think of gift, think of the story of the prodigal son. I tell you that these things are in scripture. So you remember that younger son went to the father and said, I want my share of the estate. Yes, that is what the gift would be, the inter vivos transaction. So basically, this is where you transfer the property during the lifetime. So you might want to add somebody to your bank account, and be careful who you add to your bank account during your lifetime. You may want to add them to the property. So people will say, I want to add my child to my title. And I just want to make that clear. There is no such thing. You don't add people to your title. What you do is transfer your interest to them. So when you have added a name to your title, is what I'm saying, what you in effect do in law is what we call a transfer of interest. So if John Brown owns his property at Ocherius and Miami Bay or wherever, and he says, I want to add a name. And basically what he may end up doing is to give half share to the person. That's what adding a name does. It's not putting a name. So you hear people, but my name must be at the top and which name at the bottom. It's none of those things. Once you've added a person's name to your title, in effect what you're doing is to give them an interest in land. And if that is not the intention, it is extremely important for you to make that clear. Because a lot of times when you go before the court, these things are very, very hard to disprove or to prove, depending on which side you're on. All right? And it's also important for you to consider why. And I've seen parents add their children and then they can't go to the house. I've seen it. As an attorney, practicing for a few years, oftentimes I say to people, I'm not enamored by certain things. When clients come before me, I'm going to tell them, I'm giving them the full story because I have seen many, many, many things And it's the reality of the broken world that we live in. As I said, the first murder took place between two brothers. We see it, Esau not liking Jacob. We see all kind of things happening. So it's important for you to open your eyes when you are putting your affairs in order. Another way you can manage your estate, you're talking about life insurance policies. And these policies do not attract estate fees unless, of course, the estate is a beneficiary. So in a life insurance policy, you might want to name Jane as the beneficiary, or you might say estate is your beneficiary. The beautiful thing about that is it's less costly in that upon death, Jane can just go and collect her money. You know, present her the death certificate, and she's able to collect her money. So unless the estate is a beneficiary, basically it is a very speedy way when you are planning your estate. Another one is pension plans. And listen, it's never too early to put a pension plan in place. From the day you start working, I recommend that you get one going. I'm sure our banker is happy with me telling you all these things because the bank can benefit from that. But it's the truth. You should put these things in place because the reality is that we're all going up. You know, we're all going up in age. And if we don't die young, we're going to get old. Unless, of course, prior to that, Jesus returns or we're caught up. Not true? Yes. So you can do your joint ownership as well for your bank accounts, your land. We spoke about that before. Those are advantageous in that they will eliminate some of the taxes which are payable upon death. So if you have a joint bank account upon death, last man standing, I heard that term recently and I like it, so I'm going to use it. So the last man standing takes all. Yes. And when it comes to your land, basically if you own jointly, taxes are only payable on half of the property, and it will minimize some of the costs associated. So the matter would not go through the courts, and some of the lawyer fees are also eliminated. And you won't have the estate fees such as commission to the executors and that kind of thing if you own property jointly. All right? The disadvantage to this, though, as I spoke to you earlier, is that when you put on people on your title, you basically give them an interest in your land, and what may happen in so doing, you give them what may happen. What does happen is that you give them immediate access. So the minute I add John Brown to my title, it means that if I want to take out a mortgage, I have to call John. If I want to sell, I have to call John. So I no longer have 100% autonomy over my property. John is now a part of that equation. Yes? And the reality is that even when it's a small child, if you add a small child to a title, maybe when they get big and turn 18 and you say you want to sell it, them just decide, no, I don't want you to sell it. And if you can't get them to sign, you're going to have to take them to court. These are some of the things that you want to bear in mind. Any questions so far? Any clarification? Anybody wants to go to bed? Yes. Go. Yes. Oh, you never heard what I said? I did emphasize that there's no such thing as put name on a title. That in effect what you have done is to transfer a part of your interest to that person. And unless you can show that they were only added for convenience, for example, you're not going to be able to take their names off. No, but that's what I'm saying. When you take them off, you have to take them to court. It's the point I'm making. But so I use layman terms just so that you understand. I'm saying, in effect, what you have done, having added the name, you've given them an interest in the land. So they have claim as you have. Maybe not equal, because maybe you only gave them 10%, it doesn't matter. But as I said earlier, anything that you want to do, they now have to become a party to that. So if you go to the bank to take a mortgage, you're going to ask you, where is Mary? If you went to sell it, the attorney is going to ask you, where is Mary? You've not added a name. You have given them an interest. Yes. No. only by court, but you would have to prove that the intention was for convenience. So let's say, for example, you had to do something, so you added their name. Or like I've seen situations where, and I won't call any name, people will go, for example, to an institution to do something, and then the institution tell them some crap like, if you don't put your wife's name on the title and you die, government going to take the land. And so maybe that was the reason they put it on, but you're still going to have to prove it, is the point I'm making. Maybe you're able to get that person off. I've also seen like one situation where mother sends money to daughter. The daughter puts the property in her name, but she knows it's her mother's land, and then she knows claiming it as her own. The mother was able to take her to court to get back her property. But all these things are very, very costly. I hope that has answered your question, sir. Yes, ma'am. Yes. So you have made them part owner. Yes, thank you for that. That makes it easier. So now it's you and them own it. It's not that you've added a name. It's just like how if you put me on your bank account and I draw money from the account. You can't go to the bank and say anybody thief your money because I'm on the account. And I've seen it. All the time. Any other questions? I'm going to deal with joint tenants in a little bit when I deal with the wills. So I will explain that at that point. So we're at wills, basically. And as I said earlier, this is one of the most important, perhaps if not the most important tools in estate planning. What is a will? Basically, it is a testamentary document which would have certain requirements, and it will set out how property is to be disposed of upon death. Document, so it has to be in writing, and it speaks from death. You can use the will to put in trust, as I spoke about earlier. In your will, you can name guardians for your minor children. So you may want Mary to be guardian with her father. You can do that in your will. And basically, in your will, you set out who you desire to administer and distribute your property so that you avoid the Administrator General supervision. Because if you don't have any, if you don't leave a will, basically, especially where children are involved, it is the Administrator General who will have to get involved. And you don't want that. Because that's government. And I'm not anti-government, but we know the bureaucracy. So it's always better your dear friend down the road, you can use her instead or him instead to distribute your estate. And sort your funeral arrangements in your will. So you see, it's a whole heap of things you can do in wills. A lot of people think it's just to say, I leave so-and-so to Mary or Jane. No, you can set up all kinds of arrangements in your will. Yes. And what are some of the requirements? One, it must be in writing. I've said that already. So it must be in writing. So when you have people come in, Mommy left it for me. I don't know what that means. There is an act in Jamaica called the Statute of Frauds. And especially when it comes to land, what basically it says is that if it is not in writing, it is fraudulent. Because anybody could basically say, I could then say, your husband sold me his house or gave me the house, and you have to leave. It's the reality. Anybody can say anything. So it's important for it to be in writing. Listen, I could even pass money, and nobody was there, and I got no receipt. Will not hold any water, because no court is going to buy that. As I said, it must be in writing. Especially when it comes to land, must be in writing. It should be signed at the end of the will. And signature doesn't mean you have to write your name. If the person can't read, they can put their X. If the person can't write, they can put their thumbprint. If the person is not able to handle the document at all, as I've seen, you can ask somebody to sign it on your behalf. But it must be signed. Because otherwise, what you present is just a draft. If there is no signature, we're not going to give any credit to that document. Because anybody can type up anything. Yes? And it must be witnessed by at least 2 or more witnesses who must be present at the same time. So at least 2 witnesses present at the same time. So not a situation where Mary witnesses and 2 days later you call Jane to come and witness your will. No. So whenever a will is being executed, basically at any point you need at least 3 persons. The person whose will it is in the room and 2 witnesses for it to be properly executed. All right? And it must speak from death. I paused there, I saw it at top, but I said I wanted to elaborate. What we say is that the wills must have what we call testamentary capacity. So in order for it to be effective, you must have some words saying, this is going to take place when I die. Otherwise, it's not a will. So when I die, you must see that. All right? And then, because if it doesn't say that, basically, I mean, it doesn't even matter how it is written. Of course, it's always good to get the professionals to help you on it. But it must be speaking as at death, because otherwise the court will not give effect to it. And note, only certain properties can be disposed of by will. So if you have your joint bank account, remember I said last man standing, you can't will it unless you are the last man standing. The most you can say is, if, for example, if Mary dies before me, I give my money in the bank to Jane. But if Mary dies after you, the fact that you put that in your will means nothing, because the person can just go to the bank and access their money. And it's the same for joint property. So when you have land and it has more than 1 owners, basically you can own them as tenants in common, meaning that you have a share in the land, so 10%, 5%, 50%, 100%, 40%, whatever. Or you can have joint ownership. And in the case of joint ownership, so this is what we were coming at, which is what we call joint tenancy. Basically, when one party dies, the other party gets the property automatically. So that property is not a part of the estate. Follow me? So if Mary and Jane own property as joint tenants, and Mary dies, Jane gets everything, though the other party had children and husband and all that excitement. The property will fall to the joint owner completely. And I'm saying, and I'm emphasizing that because I've seen a lot of people them ready to kill. You know, mommy and daddy own it. Mommy died. Daddy alone get it. Daddy remarries and move on. You hear, oh, but I'm a mother hard earnings. Yes. But the property was owned jointly, so it fell to the surviving, to the last man standing or last woman standing, takes all, regardless of whoever you dead left or you die leaving, even if there's a will. Joint tenants. So when you're having properties where you have more than 1 owner, it is important for you to determine how that property is held, and to do that after careful consideration. So if you have it as tenants in common, you can leave your share. So if you have your 20% or your 50% share, you can leave your 50% share. But if you own as joint tenants, like I said, the rule is last man standing takes all. All right, regardless of whatever is in the will. I just want to point out as well that wills are revoked by marriage. So if you make your will and you marry thereafter, your will is automatically revoked. I said, wills are revoked by marriage. Yes. Yes. One moment. If yes, I did say that wills are revoked by marriage. Yes. Unless when it is being written, it is written in anticipation of the marriage and it is worded in a particular way that we know it's not revoked. But otherwise, marriage automatically revokes it. Yes. I didn't hear that. Repeat that, please. Yes. It depends. A one will can revoke another will, but it would have to specifically say so. So normally what we would write, for example, is that um, I hear lawyer's language. I hereby revoke all wills heretofore made by me and declare this to be my last will and testament. If you live in another country and you had a will over there and you don't want it to be revoked, make sure you don't say that. Just say you revoke all the wills made in respect of your property in Jamaica, so it's clear that it is only revoking that thing. So just writing another will doesn't mean that the other one is revoked. You would have to say so. Because, put it this way, if it has a revocation clause. Because if it doesn't revoke the earlier will is also valid. Of course, that's going to be for the court to determine how those gifts are going to work. Not me, the court. But the reality is that it would not be revoked unless the will specifically says so. All right? Why is it important? And just to point out as well, gifts to attesting witnesses or their spouses are void. So for example, when you're getting your will executed, make sure that if you're going to give your child something, the child is not a witness. Make sure their spouse is not a witness. And the reason for that, because they're not going to be able to get the gift. And the reason for that is because the law assumes what you call undue influence. So basically, if I am sitting in the room with my mother when she's making her will and I'm a witness, it's because I am telling her what to put on it. That's the view. So it's important for you to get independent witnesses who are not named as beneficiaries. Your executors can be witnesses, but not the beneficiaries, because otherwise they're going to lose the gift. All right? Just to make sure that you know, I'm coming to a close. Why is it important to make a will as well? Because you are able to make provision for persons who would not be able to benefit under the laws of intestacy. So what do I mean by that? When a person dies without a will, in law we describe them as dying intestate. So testate, you left a will. Intestate, there is no will. Or the will didn't cover all of your property. No. There are certain people that do not automatically benefit under intestacy. People like aunts, stepchildren, godchildren, your helper, your friends, your neighbor, and all these wonderful people who may have been the best persons in your life. Rather, they are not going to be able to benefit from your estate unless you say so in your will. Yes? So you may have raised that child over yonder as your very own. But if you do not indicate that in your will, the child will not be able to benefit. Yes? And let me tell you what the intestacy laws say. And people don't like it. But it's what they say. It's not me make them. The government makes them. The better thing to do is to write your own so that the law doesn't determine who gets what. So this is how intestacy shares up And I'm not going to deal with personal chattels. I'm going to deal with like your furniture and your motor vehicle. Well, I could say it. If the person dies without a will, the spouse takes all the personal chattels, furniture, motor vehicles, etc. Yes? So even including the wayward spouse, including the spouse who cheated and disappeared 5 years ago. What was that over there? There can be no private jokes in here and I have to share it with all of us so we can laugh too, right? Yes. So, and basically, the spouse also takes all of what we call the residual estate. So whatever else is left. So remember I said I get the personal chattels, the furniture, the jewelry, blah, 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 the motor vehicles. And anything else that is left, if there is no child or parent, the spouse takes all, including the wayward spouse. Because the law doesn't define spouse as the spouse who treated you good. The person you're married to, or in the case of a single people who have been living together for 5 years or more. Yes? If there is a child, the spouse gets 2/3. We don't like it, but it's what the law says, not me. If there is more than one child, the spouse takes half. So if John dies and leaves 10 children and a wife, wife takes half, the other half is shared up between the 10 children. If you don't leave a will. All right? All right. If there is no spouse, yes, sir. I'm sorry, I didn't see that. Because remember, I did say that marriage revokes a will. So you'd have to republish your will or make a new one. No, that's not what we're saying. We're not saying don't get married. We say put, remember we talk about put proper provisions in place. Yes, ma'am. That could work. Basically, we're doing it. Yes, yes. All right. So I was saying that if you die without leaving a will, remember I tell you what the spouse gets. All right. Children, no. Basically, if you had children and no spouse, the children take all. But remember, I did say that if there's a spouse gets 2/3. If one child and the spouse gets half if more than one child. And if you have parents, the spouse gets 2/3. So even though it was the parents who took care of you until the day you die, and spouse gone about them business and no business with you, the spouse gets 2/3. That's what the law says. All right. Now, if you die without a will and you leave your parents, they take all only if there is no spouse or child. So if children are involved, your parents get nothing. You see why it's important to write your will? Because you might have an elderly parent that you want to get something. And if there's a spouse, the parents get 1/3. I'm sure most of us don't like them sharing there. So at the end of the day, it's important for you to put your will in place. So you see, people have a way if you say, my brother dead and them come and they want. You notice I haven't even mentioned them because when you don't leave a will, the order of priority starts with the spouse. The spouse is at the top, then the children, then the parents. And it is only when you don't leave any of those people that brothers and sisters start to come in place. There you go. And a lot of times, yeah, there's the fight because the children who are bad, don't want the new wife is now going to get two-thirds or half because they think, what did he do or she do to get that? But if you don't leave a will, that's what happens. Although I believe that children must have their own. But that's for another day. So yes, I said if you don't have children, spouse, parents, then basically brothers and sisters and uncles and aunts come in. And basically if you have none of those relatives, that's where the government comes in. So contrary to popular opinion, if you don't leave a will, it's not for government. But it is the law who determines the order and the amount that these persons are going to get. Well, that's a different thing. That's a different thing. Um, you should also note that generally speaking, wills can be contested once they are done properly, but there is a provision in law that allows dependents to be able to claim, even though the will might say otherwise. So what am I saying? If you make a will and you normally take care of your parents, so your parents are totally dependent on you, and you didn't make any provision in that will, that parent is able to go to the court to get an order for certain provisions to be made to them from your estate. Similarly for children who are dependent and so on. All right? Any other questions? I think I'll just pause there. Any other questions? I hear mumblings and I... Yes, yes, sir. happen. No, these things happen. And so and you see, another thing as well is that sometimes because, I mean, I am not anti spouses acquiring property together, even if one party didn't contribute. But sometimes, you know, in the name of love, you do it, and then at a later date now you say, but he never contributed anything and you want him off. No, it doesn't quite work like that. No. Usually what I do, I encourage parties that if you don't feel comfortable because the person is not contributing, perhaps what you can do, instead of making them a joint tenant or giving them half, maybe you can just give them a smaller share in the property to show, yes, I want you on it, but not for 50% since you're not able to contribute. It's a matter for you. I don't get involved. When it comes to that side of my work, I just say what the law says. Yes, sir. Yes. Well, you can have, remember I spoke about the trust arrangement. So for example, you could have an insurance policy and you give me the policy and I'm beneficiary and nobody don't know. I go sort out my thing when you die. For example, if there's a will, sometimes people do that and they put it away. Sometimes it's with the attorney. Sometimes somebody come up and show a document and people might say, no, go so. It's for you to prove if it's the person's disproved the signature or whatever. I mean, what can we do? People do their own thing, no matter how you, because some things are done in secret. The reality is that, and I've seen some clients, when they write their will, they don't want the people to see. Because some people, when them see the will, them kill you quicker. I truth. Man, you can't benefit if you murder the person, but I'm just saying, people do that when they see that they're not able to get certain benefits or they don't like what is there. I have seen it. I have seen people come asking me to change will, and because the other party don't want to change it, they threaten them. You know, like, not necessarily to kill them, but you're the pay your own. I'm not give none more money, and I've seen so much. You know, I've seen children cussing over it because, and he never give mommy nothing. I mean, used to buy a chicken back, give mommy. I mean, you hear all kinds of things in the work. So, but it's important. If you learn nothing else, all I'm saying tonight, put your house in order. Put your affairs in order. And here's the thing, and I didn't remember to point it out. Just a point, if you look at scriptures, for example, you see we're talking about what happens in terms of intestacy. The reality is that in Judaism or in the Jewish culture, basically it was the sons who inherited. Right, Pastor? It was the sons. For example, Numbers 27:8 tells us that if a man dies and he had no son, that's how the daughter would get the estate. It was the sons, and the men were responsible for taking care of the women. But generally, it would pass to the children, the sons rather. And if you had illegitimate children, basically they had nothing to get. So when you read even Galatians and you see where Paul said, cast out the bondwoman and her son, because the bondwoman's son could not inherit. So it was the same thing. And just to point out, even right here in Jamaica, up until 1975, children who were born out of wedlock could not get anything. And so back in the day, the government got a lot of properties because illegitimate children could not claim in an estate. Even when you write your will, suppose you wrote your will as a father and say, I leave it to my children. Unless there were children born in wedlock, they wouldn't get it. So if you had 10 children and 2 were born in wedlock and 8 outside, only the 2 in wedlock, because would be recognized, because children who were illegitimate, they would call them bastards. You know about that. And the law basically called them filius nilius, which meant children of no one. So they had nothing to get. So I'm saying to you that some of the laws you hear me talking about, some changes have made. It's nothing new. Here's the problem. A lot of people do not know the law, and there's this sense of entitlement that I should get because I was the one who took care of mommy until she died. But mommy never leave no will. I have seen it. I had a situation where one of the beneficiaries disappeared for years upon years upon years, to the point where the family thought he was dead. But upon death, he came and claimed his half. Yes, that's what happens when you don't put your affairs in order. You may have had 3 children, one disappear, went to England, you never hear from him again. He never one day wrote you, called police, you do everything to find him, and he never wanted to be found, but he heard you die. You didn't leave a will. He came and he comes and he collects his 1/3. That's what the law says. So I'm saying when you put your affairs in order, you are the one who determines what happens to you, what happens to your property, what happens to your children, what happens to your spouse. You are the one who is able to make that decision. It is not the law that makes the decision for you, and so effectively you are able to speak from your grave. Yes? Yes, ma'am. I did say up until 1975. So this, under the Status of Children Act, as at 1975, all children were recognized. Because at the time, basically, yeah, they said no more bastard. Well, he would recall, because that would have been a slogan for election back in the day. Under Michael Manley, basically, I think at the time, like 75 out of every 100 children born here were born out of wedlock. So you can imagine 75. Now we're at about 85 children out of every 100 are out of wedlock, which is really, really sad, because we know that's not what God wants, but it's what it is. But at least now, out of wedlock children can inherit and are seen as children. So we're no longer children, and I say we, because I was born out of wedlock. We are no longer children of no one. We actually belong. They're still able to claim, but you may have to do. If it is known that it was their father, they have the name and whatever, but otherwise, declaration of paternity may have to be done before the person can claim anything. Yes, ma'am. No, I'm not saying that it's best to have a trustee. I'm saying you can put trust arrangements in your will, especially where children are concerned. But in your will, you don't want to name your executor, who is the person that is in charge of distributing your estate. But you may want, I have a lot of people's wills, you know. Some people make them will and leave it with me. They don't want the children to see it. They may say to the child, I made a will and my lawyer has it. But the child doesn't know what's on it. And the child cannot come to me unless the parent has passed and unless they're an executor, because it's only the executor who would have the authority for me to give them the will. Well, I don't know either. Well, the truth is wills can be recorded, but some people don't record their wills. So usually what we advise people do, that's why I say if you put it in secret, what can we do? I normally say to my clients, whenever they want me to keep their wills, I normally say, make sure you tell the children that I have it. Or at least I give them a letter so that they'll see, if they put the letter away, the child can come across a letter that would tell them that a will was written. So they'll at least go to that attorney's office to find out if a will is there. And what we've seen other children do, if they know that, for example, daddy used to use that lawyer down the road, they'll go, my father has died, did he leave a will with you? So the prudent child will make his or her investigation. Yes. But you don't have to give it to the attorney. You can keep your will at home or your deposit box or whatever. It's a matter for you. Yes, you tell them that your attorney has your will. Yes, ma'am. You have to. Well, no. Yeah, the intercessory laws. Somebody is learning. Yes. I give you 100% would chip in. Yes. No, you see this idea that's why I said when they say lawyers take over land. I mean, I'm not going to say that all of us are honest people, but the reality is that it's not so land take over, is the point I'm making. Remember, especially lands which are registered, there's a title for it. It's not as easy for me. I would have to be saying that you sold me the land or gave me the land. And the truth is, I couldn't say you give it to me because if I'm to take a gift from a client like that, we have to make sure that it's above board because the way that the law is structured, the court can take it back from me. So it's not as simple. Sometimes you hear things, but it's not everything that you hear is true. It's not as simple as that. Anything is possible. But anything is possible because your own child can go and transfer it. And that would be fraud. Yeah, the reality is that most family would not sit down if they realize that the property has gone to the lawyer and not go and do an investigation. That is just the reality. So I'm saying to you, though it is possible, it doesn't mean that it happens with the kind of frequency that people think. Usually the fraud takes place with families. Yeah, they take the lawyer to court. No, you wouldn't sit around if you know that I'm your mother's lawyer and then all of a sudden you find the house that your mother was living in comes over to me. You would not sit around and you would want to know what happened. Something must have gone down. That's the reality. So if somebody just sits back and not do anything about it, then it's what I'd say perhaps, no, and I won't go there. Yes, sir. Yes. Exactly. It's important for you to know the law. I believe that with all my heart. Sometimes people are against education, but I tell people there is no bliss in ignorance because not knowing is dangerous. It's the reality, not knowing. And one of the not knowing, I've seen it. Children will come to me, oh, daddy left the land, I threw away, and I me one living, so I'm mine. No. That's not what the law says. It's for the three children. And so the ones who have died, their estate is entitled to their share. And I find it very difficult at times to try to convince clients that it's not theirs. Because just because the person has died, it doesn't mean that their share has died. Their share passes to their generation. But they don't want to hear that. You see why I'm saying it's important for you to put things in writing? You save bloodshed. Because we see it, even in fact, in the news recently, I think it was, with that death in Clarendon, it is alleged that it was over deadlift. Yeah? Yep. Yes, sir. Well, if they don't do anything about it, I can't do anything about it. Yeah, they could get, but it's assuming that you can get it back because sometimes by the time you go after that brother, he would have sold all kind of things probably would have happened. And not to say that even if the land was sold, you can't undo, but sometimes it's just a hot mess to try and undo what was done. But yes, I've seen it. A lot of times people feel that just because I'm the last man standing, I take all. And that's not the situation. Or because I'm the children and I'm the child, rather, and she is the stepmother. She's not supposed to get anything because my father had it before she. No, that's not what the law says. Yes, ma'am. So those executors would also more likely than not be trustees. That's what remember I talk about setting up your trust. So in that will, so you have and I didn't make the point, but I can now that you've asked the question. You have simple wills, you have some which are a little bit more complex. So in your will, you can even say, for example, oh, I leave John and Mary as trustees, executors and trustees, and I give them my house upon trust for my daughter Mary until Mary is at the age of 25. So you can say they can rent out the property, they can use the income for her education, advancement, and that kind of thing. All of that is how your trust arrangements would be. You don't have to make it just blank and blah. You can set out what you would want to happen to the child in the will. So that's why I said you can put a trust arrangements. Because remember, I did say you don't want to give the child at 18. You'd want to be able to give it to them at an older age. And you can even set up trustees so that you have settlements, so that you have it, they have it on trust for that set, and after that set die, it's for another set and that kind of thing. Yes. What is a power of attorney? So basically what that document is a document where in that situation, when we speak of attorneys, we are not speaking about attorney at law. What the power of attorney is a document where the donor gives the donee or the grantor gives the grantee the power to do certain things on their behalf. So the person who is given the power is who you call your agent or your attorney. Attorney, yes. Mhm. If the person is still capable, they can revoke it. If they're not capable, you can actually go to a court. Because the reality is that they're agents, so they have to do in accordance with the document. And if certain things are not happening, somebody can go to court and see if they can override what happened there. Especially because they can ask for the person to account and ask for the person to be removed. But remember that I did say that they can be called to account. Because remember that they're your agent. It's not that they can do as they like. If they're handling your money is your money on your behalf, so they can be made to account for the money. Because basically they're your trustee, so they're doing whatever on trust for you. But that's why I'm saying a relative can step in and see if they can go to court to have it. Just like how you can have an executor removed, if you can go to court for the court to deal with it. Yes, executors are entitled to, if they want, up to 6% of the estate. Remember, I spoke about it. That's why planning your estate helps to eliminate some of those costs. Yes, ma'am. You can leave it on your will or you can add them while you're alive. But I should also point out as a caveat, remember when it comes to matrimonial home, that's a whole different game. Pardon? Yes. A person can still claim under a matrimonial home. Basically, you see, a lot of people think that there are a lot of benefits in marriage. There are benefits. Unfortunately, Our law is not as friendly as elsewhere, where they say that if the person dies, half goes to the other spouse. It's not quite like that. You get what you put in, except for the matrimonial home. So if the person has 10 properties, it doesn't mean that let's say husband and wife, husband owns 10 properties. It doesn't mean that the wife on a divorce, for example, would get half. No, but she could get half of the matrimonial home. So even though she never contributed any money, because that is where they lived and it was a family home and the main residence, she can still claim her half. So just to point that out, that wills may be made, but the reality is that the matrimonial home and the rights under that can affect even what you put on your will. Yes, sir. Yes. Yes. You probably could. Because there is actually allowance for you to be able to dispossess an owner through adverse possession, which is the same as squatting. So I could own property jointly with you, going about the business. I'm the one paying the mortgage, doing everything. Ultimately, after 12 years, I may be able to say it's all mine under law, just as anybody else living at another property for 12 years. Any other questions? That's it? All right, thank you. Thank you for your time. Thank you for listening. I hope we all learned something.
Okay. We're going to divide some work here now, right? Make some division. Pastor John will come and give the vote of thanks. And we're going to ask